Hello and welcome. My name is Ali Goff. I'm the owner and founder of Goff Legal, and I'm going to be spending a little bit of time with you today on the One Big Beautiful Bill Act we're going to call OBBA because it's a lot easier to say. My firm does estate planning and trust administrations here in California, and this law has some specific things around estate planning. I'm not going to go into almost any of the income tax planning, but things like this. It's too many pages. Most people didn't read it, and half of it's being litigated. But what I'm going to tell you is the thing you need to know if you're a California resident and have an estate planning question, because there's some things specifically that I think you're going to want to know. So the first thing is most of this law is effective in 2026, some of it in 2025. So just know that. There's a few things that are related to gifting and some charitable gifting options. We've got some non-itemized deductions, right? You get to, if you're not an itemizer, you're allowed to deduct $1,000 if you're single or $2,000 if you're married filing jointly. That's wonderful. So that's something you didn't have before. This doesn't, however, apply to donor advised funds or private foundations. So keep that in mind. Obviously, you're going to talk to your tax professional before making any of these particular gifts to make sure that you're making them strategically and smartly. There is an income, there's a cap for high income donors, meaning in 2026, if you are donating to a charity, your deduction is capped at 35%, even if you're in, say, a 37% bracket. So, example, $10,000 donation is going to save you 3,500 instead of 3,700. Our pro tip here, talk to your tax advisor, is to consider giving in 2025 because we don't have that yet. It's not effective until 2026. There's also a floor, right? So we have ceilings and we have floors and we have caps and we have all sorts of stuff. The floor, only your donations exceeding 0.5% of your AGI, which is your adjusted gross income, are deductible, and only donations over 1% of taxable income for corporations count. So, really, the strategy here is encouraging larger, less frequent gifts. So, if you're going to give, let's figure out a way to do that rather than 5,000 and 5,000. Maybe you bunch it and go 10,000 because you're going to hit that floor, right? You want to hit the floor, otherwise you're not going to get the deduction. By the way, there are many different reasons you would want to give to an organization that don't necessarily involve taxes. So this isn't a stop giving. This is make sure if you're giving for that specific purpose, that you've got some intentionality and some good advice around how the laws have changed for you in 25 and 26. But here's the big thing. The biggest news that I think impacts most of the clients or has shifted some of the landscape is the federal and estate gift tax exemption. So the big news here is that it has risen to 15,000, sorry, that's thousand. That'd be bad news. 15 million per person that you can give away during your life and after death and not pay federal tax. That's great. That's wonderful news. It had been as low as hundreds of thousands in the past. It was then 5 million indexed for inflation. What was going to happen is that law was going to sunset here, and we were kind of not wondering what was going to happen. Now they have designated this permanent. I'll get into permanent in a second. Permanent meaning if you're a couple, you can each donate or give away in any way during your life or after death, $15 million each, so $30 million. When I say the word permanent, nothing is permanent in the law. The legislature could change this in the future, but these are the rules we're governing and we're dealing with right now. Why this matters to you, if you had somewhere between 5 and 15 million or anywhere above $5 million as an individual, don't forget your life insurance counts, your real estate, your brokerage accounts, your retirement accounts. This is everything. You and were married, you might have had what we call an AB trust. You might have some more sophisticated tax planning built into your trust because it was necessary to avoid those federal estate taxes. Let's just say you don't, now you have $5 million and the exemption is 15 million. You might not need that tax strategy in your account. And it's really important that you meet with an attorney, have your trust reviewed, and possibly updated to reflect the current tax laws. There's also some gifts that we don't have to make. There was a lot of people who were giving away assets and transferring assets because they were worried about going over this limit. You can keep a lot of that now. Obviously, a team approach to this. Estate planning attorney, financial advisor, and CPA are going to be the best three collaboratively to work together, maybe a tax attorney, depending on the complexities, to make sure we're making really smart gifts. We're still avoiding probate. We're also avoiding federal estate tax and making things really easy for your family. So, if you want more information on how we work as a team, you can check out our website at Goff Legal, and we're happy to have a conversation with you and have a free discovery call to see if we're a good fit. Thanks so much for watching.